Okay, Radish, Solom Smith.
Just reach for my water. I'll never be president.
Greg, I'm not sure, I'd have to go through your categories again, whether my concern was put in your categories. I label my concern non-contextuality, and I should preface this by saying I'm once again suspending disbelief in the viability of the entire operation, but assuming originalism is what we want to do, I think non-contextuality is a serious danger, and I think Larry sort of hit on this, but then sort of dropped it, didn't seem to think it was a problem. Words in a governing legal text are put there to get to a point B. There's a purposive connection to it. When you look at a dictionary at a word freestanding, when obviously the person writing the dictionary has no clue that you're using this to get to a point B, you could get to a completely incoherent result even, to the extent you rely heavily on this. I think of the words, looking up the word do and the word process, looking up the word freedom and the word speech, looking up the word equal and the word protection, or the word privileges, or the word immunities. Divorced from their purposive textual context, I think that's meaningless. Now, it doesn't hurt to look at the definitions in some sort of a probative sense, but I get the feeling it's become much more obsessive in the use of them, and this, I guess, is an argument more for original intention than original meaning, because original meaning just divorces the word from the purposive context in which it's been placed.
Solom, Larry.
I did qualify this.
Yeah, so just, and I think that, the dictionaries report usage, right? That's what makes them useful. If they're not reporting usage, then they're not useful. So you just might want to suggest in your guide that we can check the dictionary definitions against usage, right? And, Randy does this with commerce, for example, in his Commerce Clause work. But, Larry, I think, may be able to tell you a little bit about how a certain kind of linguistics is conducted this way with, this is John McGinnis's point about big data, by accessing large numbers of usages at the right period, you can check the dictionary against the usage. And that used to be really hard to do, so it wasn't practical for a lawyer or a law clerk to do that kind of research. But because of the electronic databases, it's now much more practical. And therefore, it seems to me, if you're writing a sort of prescriptive guide to the use of dictionaries, this is a step that, if we're looking at, old words, ought to always be conducted, right? And so I just offer that as a suggestion.
Steve Smith.
I have one tiny question, and then I think I'll do one that tracks Marty's comment to some extent. The tiny one is this: in the paper, and then also in your talk today, you say the dictionaries would be mostly useful for figuring out the original objective meaning of words, but they might provide some assistance to writers attempting to discern the original intent of the framers, original understanding of the ratifiers. But dictionaries serve this role when researchers use them to look up not the words in the Constitution, but instead the words spoken or written by the framers and ratifiers about the Constitution, like in the Federalist Papers or something like that, I take it you're saying. And I just didn't understand why you would limit it in that way. Why it wouldn't be perfectly useful. Dictionaries might be perfectly useful in figuring out what the original intention of the framers was in the words of the Constitution. So I just didn't understand that qualification. I'd be interested to hear what you have to say. My other question probably goes the opposite direction, though, in a sense, and that is, It seems, I was trying to think, how often do we use dictionaries in our ordinary activities? And I'm sure that varies from person to person, but my observation is when you're like encountering a foreign language, or a person who's speaking a foreign language, and maybe you know a little of it, but not, often you'll use a dictionary then. Or when a speaker, this will happen to me quite often with certain speakers at least, uses some word that even though it's an English word, it's part of the English language presumably, I just have no idea what it is, then I might go to a dictionary. But in almost all of the debates we have, or just discussions we have, which I think are pervasive about, what did this author mean in this newspaper article or this magazine article, or what did this politician mean, and he or she said this, and we just have lots of discussions about those kinds of things. And my observation is we hardly ever turn to dictionaries for those things, and it would seem kind of odd to do so, because we sort of think, well, we know basically what the words mean, but that there's some core meaning of the word that we probably sort of understand. But the whole task is to figure out in this context, in this conjunction of words and part of this speech and so forth, what did they mean? And a dictionary would seem just not very helpful for that sort of thing. So now if you think back to using a constitutional interpretation, there is one other possibility here that you and others have mentioned, that is the word might have changed even in its really basic meaning quite a bit over 2 centuries or whatever, and a dictionary might help to identify that. But beyond that, it seems like these are more like the kinds of interpretive things we have all the time. And I was thinking of one instance, this has maybe been like 15, 20 years ago. Somebody sent me a draft of an article he had written about the original meaning of the Establishment Clause. And I thought I'd be interested in this. I mean, I was interested in it, and it was from an author that I respect quite a bit. So I thought, this is likely to be good. But it really used the dictionary approach. What did respecting mean? What did? And I remember thinking, this just seems really obtuse somehow. Maybe it would identify some completely different usage than what I expect, but mostly this seems like a matter of figuring out what the political context was, what, as Marty said, what they're trying to achieve with it and so forth. And it did occur to me that there's some risk that, well, let's put it this way, though surely there's nothing wrong really with looking at a dictionary, just in case it might be helpful, there is some risk that this will sort of skew things out of the more contextual way of interpreting that we normally would think is the appropriate thing to do. And so that's just that's not exactly an objection. I think it's just kind of a concern or a reservation about putting much emphasis on dictionaries.
Okay, well, thank you very much. I think we skipped a step, which was I was to make some comments about Larry's
that was my
remarks.
fault.
And
I'm sorry.
so let me first talk about Larry, then I'll go to Martin. Sorry, my comments will be extensive. Larry, I thought all of your comments were right on point, and I think you know a great deal about dictionaries. I probably want to talk to you offline a little bit about some of these topics. Certainly, when you say good contextualizers, I put that in the inapplicability category. That was my example of no one would think that vessels would, when they're obliged to pay duties, that they're happy to do it. The imprecision, I think, is where you what you say not resolving good borderline cases. I think you're exactly right on that. I like your example of the sofa and the love seat. I do think there's a lot of gotcha here, where people say, well, we win because I found a dictionary that says we win, and nobody's really trying to figure out what the word means. They're just trying to find some supporting argument. I didn't know about the order of definitions point. I'm going to put that in there. That sounds very, very good. And I completely agree about looking at many dictionaries and triangulating. Moving on to Marty Reddish's point about, well, there's sort of 2 points. One was about non-contextuality, and the other was about originalism. I suppose on the non-contextuality, there's sort of two things that are going on. When you mention something like due process, there is such a thing as a word compound, which has more than one word, but is really one unit. For example, vice president. And if you don't look up vice and then look up president, that is it's sort of one phrase that you would look up together. And certainly, it would be a mistake to break apart a compound and then look up only one half of it. In terms of the other contextuality, I would say that fits into my category of insufficiency, which is you may know what a particular word means, but it doesn't necessarily decide at all what the Constitution is. We know what the word recess means, but when we talk about an appointment during a congressional recess, that's a specific term that you have to get from the whole context, and that's exactly what I think the issue of, you may really want to know what a recess is, just in case you're mistaken, but about that term, but the dictionary won't decide that, so I agree with that. On your other point about how this calls into question everything about originalism, my article is not a defense of originalism. My argument is really just what would be helpful to somebody who's faced with the task of either trying to make a persuasive argument about the original meaning or to evaluate somebody else's argument. And I think you have to be just sort of assume that this is going to happen whether you like it or not, and what all we can do is make the kinds of arguments or the level of discourse better, and people shouldn't be relying on it too much, or they should try to think of ways that improve it. In terms of Larry Solom, I like your idea, and I do cite Randy's article when I talk about the different kinds of original meaning, the original intent, the original understanding, and the original objective meaning. Looking at dictionaries is just one source of the original objective, original public meaning, and certainly you should look at other sources. I think Justice Thomas does that in the Lopez case. He looks, like Randy does, at a lot of different sources of what the word commerce means. And I think it should be a standard practice not to look at only all the dictionaries available, but also to look at other usages. It is a lot of work, I think Randy could tell you that, to go through all of the different sources. That's probably why people turn to dictionaries, but I don't disagree with anything you're saying. For Steve Smith, I think there are, I didn't mean to exclude the idea that the dictionary definition and the Constitution, or assume that there wasn't a congruence of original intent of the framers, original understanding of the ratifiers, and the original public meaning, and that ordinarily we would assume that people would use their words in the way that they're sort of generally used. My only point was that if, for example, you said we don't care what the public meaning is, we care about what Alexander Hamilton thought, and Alexander Hamilton said in Federalist 78 that courts can review the constitutionality of statutes to see whether they're against the manifest tenor of the Constitution. We might want to know, well, what did he mean by manifest? And that's, looking up the word manifest really doesn't have anything necessarily to do with the public meaning of the Constitution. It has to do with what Hamilton is thinking about the meaning of the Constitution. That was only my point. I wasn't trying to make any sort of strong claim that we shouldn't start with the idea that the framers and the ratifiers also understood the Constitution according to its public meaning. I do agree that it is somewhat artificial to look up all kinds of words when we don't usually do that. It has now become standard practice, as I said, in all the constitutional cases to cite dictionaries. And it seems a little weird because we don't do it in all statutory cases. We don't do it in ordinary discourse. I don't have a category for that issue. I have to think about how to include that, but I completely agree with that statement. So I agree with everybody. Thank you for those comments.
I'd like to just elaborate on what Larry was saying before about linguists. There's a subfield of linguistics called corpus linguistics, where they try to draw inferences from actual usage, and there are huge databases of literature which you can access. One of them I think is called the Bank of English, and that will have a lot of British literature, and you can limit it to a search through a time period and see whether you get multiple occurrences of a particular expression. And if you do, again, you can triangulate. You could be, your own lexicographer to some extent. And it's certainly a good practice as compared to just trusting Samuel Johnson, who had only one, 3 or 4 words about something. It's good additional information. It is big data.
Okay, Larry Alexander, Will Bode, and Mike Ramsey. Larry.
I like the paper. It's very measured, modest in its claims, and I like Larry Solin's gloss on the paper as well. So I don't have any criticisms. When I would think that, when do we, just sort of going to what Steve Smith said, when do we look at dictionaries when we're trying to understand the semantic intentions of some speaker or writer? Well, if we think that our normal understanding of the words might be different from how those speakers or writers understood the words because there's been historical change and we don't exist in that period, and we know that words and expressions change their meaning over time, that the usages change. And so I would think that if we go back, if we're looking for what might have been the meaning of a term in a different period, we would not look only at the dictionary from the period, but we would look at dictionaries from a period after that. Because as we know now, as we know from our own experience, I bet you if you went and looked at the dictionaries today for the expression begging the question, you would not get the way it is now being used or misused. And that, unfortunately, in the future, it will probably become an accepted meaning. And so you would not pick up the misuses that are going on at the time that become later, captured in the later dictionaries. So it seemed to me that what you'd want to look is over a span, as opposed to just the contemporaneous dictionaries. There are all sorts of my pet peeves about misuses that become accepted, but they occur, and they occur in legal instruments at a time when, if you looked in the dictionary, they would not be accepted. So it's just a gloss on the work.
Well,
So I assume the reason we use dictionaries to look at historical materials is because the past is a foreign country and they do things differently than they are. And so it's much like translating into foreign languages. But I have one question, which is maybe a modification of Marty Reddish's point. Which is, it seems to me you might want to break out phrases as a separate category of you could call them inapplicability, which I think is what you suggested you were doing in your remarks earlier. But it seems to me that the Constitution probably contains a lot of phrases that aren't easily decoded into their constituent parts. During good behavior, office of trust or profit under them, necessary and proper. And unlike Vice President, I assume dictionaries didn't contain phrases like that. Particularly, there's no way to look them up. They might happen to be mentioned in the definition of something else. And so they might just be their own kind of problem, and that would depend in part on how many phrases the Constitution has and how much that matters. And then I also wonder whether it would be useful to divide the dictionaries into pre- and post-framing. Maybe not, but you could imagine that having had various words used in the Constitution would cause dictionary writers to have a view about what definitions to prioritize or what definitions they thought were important. And so if so, then at least you'd want to pay attention to, did the definition in the dictionaries change pre- and post-framing?
Well, the first part of what Will just said was pretty much what I was going to say, so I'll just say it anyway with an example. But I think it also connects up to another one. That is the point about that there are a lot of phrases that can't be disaggregated into particular words and then looked up in the dictionary, and similarly the phrase can't be looked up in the dictionary. I should preface this by saying this is a great paper and it's very useful, and I'm just going to push back a little bit on dictionaries relative to some other sources without saying that dictionaries are the wrong thing to be looking at. But I think that there are times when they're not that useful, and I think the phrases are an example. And then I was going to connect it up with another area where I think that renders the dictionaries somewhat problematic, and that is that typically a dictionary is trying to get at a general usage of a word, rather than a specialized usage of the word. And sometimes they'll, especially modern dictionaries, will give specialized ones. Older ones, I have the sense that they didn't as much. But when we're talking about law and we're talking about Constitution, and we're talking about particular subjects of law, then you may be getting into a specialized usage of a particular community that would have been quite obvious to the people that were doing the writing, but it's very difficult to capture it in the dictionary. So the example that comes to my mind, because I've struggled with it, is the phrase to declare war, which is, I think, an example of both of these problems. That I know, because I've done it, that there isn't any entry for, you can't look up declare war in a dictionary. They doesn't have a definition of the phrase in the 18th century dictionaries. If you split them, and you can look up declare and you can look up war, but it doesn't really get you the sense, it doesn't really answer the question of what a declaration of war is by doing that. And similarly, you have a problem that declare war comes from international law in a way that is not likely to be captured by the dictionary in the definition of the component words. It has a specialized meaning that people would think about when they were using it, but because the dictionary is thinking about a broad, and I think regulate may well be something that falls in this category as well. Is that when we're talking about regulate in a legal sense, that's perhaps different from a more general use. But in any event, it just seems to me that while dictionaries are one tool, that the actual evidence of common usage along the lines of what Larry Solomon was talking about is, if you can get it, is stronger, because you can often then see that both the uses of the phrases, the words together, and also the uses within a specialized context or within a particular community in a way that a dictionary just doesn't really capture. So I guess those are just sort of qualifications on these, but not to undermine the idea that, dictionaries can be useful, and if we use them, we should do them right.
Okay, well, very helpful comments. Larry Alexander raised the question, addressed the thing. I really think I'm going to add a section in the article about when should you look at dictionaries, or why should you look at them. And I think the idea is a central one that I see it obviously now, that if you suspect that the meaning of the word has changed over time, that would certainly be a very important time to look it up. I had a little bit about this, then I took it out. My example was that in his diary, George Washington described his visit to Charleston, and he found all of the inhabitants there to be gay. And I thought, you probably wouldn't phrase that the same way today. And so,
Go back as far as George Washington.
yeah. But no, I think that was a very good point. I think phrases being a separate category is a good idea. It is true that you can look up some phrases in a legal dictionary. So, for example, corruption of blood appears in a legal dictionary, and I imagine I don't know if declaration of war does, but there might be some other ones that are maybe even due process that would appear in legal dictionary. And they did have legal dictionaries in the 1700s. I have some references to those at the end of the article. All of those have been cited in Supreme Court cases. But I think you're right that I don't think it's going to help. It's a limitation on the dictionary, and if what you're looking at is a phrase, the dictionary is not going to give you the answer, and the dictionary is also not going to tell you that it's not giving you the answer. So that is certainly a problem. In terms of pre- and post-framing dictionaries, the Supreme Court has been very rigorous about pretty much citing pre-framing dictionaries, with one exception of Noah Webster's dictionary. All the other pre-framing dictionaries were British dictionaries. Noah Webster's dictionary is from 1828, and it is always included right along with all the other dictionaries from the 1700s, with no explanation as to why they're all of a sudden looking at an 1828 dictionary. Now, I suppose one thing is dictionaries take a really long time to draw up, and at the time they come out, they're always based on texts that were made much earlier. So maybe it doesn't matter so much in the sense that, they're all, even if it's 1828 dictionary, it's probably looking at things that were written in the 1790s or 1780s. But I think that is something I should talk about. Again, Mike also brought up the phrases, and I think declaration of war is a great example. That you can look at declare, you can look at war, you're not going to get the answer. It might be in a legal dictionary, or it might not be. I think if it's in a legal dictionary, then it's important. One thing I point out, though, is you can't just look for things in a legal dictionary first, because if you look up the word consideration, the word consideration in a legal dictionary is not the way the Constitution uses the word consideration. Consideration is a contracts term, but the Constitution, when it uses it, means just to think about things. And I think, again, dictionaries are not the most perfect source. I think looking at a corpus of words and seeing how the words are actually used is extremely important. There is a difficulty in that, which is it is very difficult for other people to assess the correctness of your work. If you say, well, I've searched and here's some newspaper examples and they show that regulate meant this. I think it was Professor, I'm having a senior moment here, Krosky at the University of Chicago. Can I have a senior moment when I'm at 48? I think so. My father, I said this, I couldn't remember something the other day, and my father says, it's bad when your kids are having senior moments. Professor Krosky found someone who had said that she had found a fly among her soup in a newspaper article. And from the fly among her soup, he concluded that among could mean wholly internal to one single thing, and therefore the Commerce Clause could mean regulate commerce among the states, could mean commerce in just one state. So, you know, just because you found a usage of it, I would think that, you know, you're kind of replicating the role of the lexicographer in deciding what is the common usage there. You might not be as good as Samuel Johnson. You might be better because you've got big data available to you. I think all the dictionary definitions that I looked at that were, all the cases citing dictionary definitions that I looked at that were the most suspect were where they didn't cite many other sources. You know, and I think you just get into trouble if you look just at the dictionary.
Will and Mike's comment raises a related problem, which is when you have a single word and you define it and the definition is more than one word, which happens most of the time. There'll be two simpler words or more. And then the court uses the words in the definition as for analysis as a substitute for the original word. You wind up with what philosophers call the pet fish problem, which is that the prototypical pet is a sort of a setter or something like that, and the prototypical fish is a trout or a salmon, but the prototypical pet fish is not something that's half dog and half fish. It's a goldfish or a guppy. So I don't know any constitutional cases like this, but the Supreme Court started a big jurisprudence of RICO interpretation by saying that a pattern of racketeering activity, the word pattern means continuity and relatedness. So now you see hundreds of cases that have relatedness analysis, continuity analysis, and you can't tell, if you just use the word pattern yourself and said which of these looks like a pattern, that there's often not really a very strong relationship because they've taken the defining terms and substituted the defining terms for the terms that the original term. That's a danger in using the dictionary that needs to be avoided as well.
Okay, Mike Rappaport, Randy Barnett, and I put myself in.
Okay, so I thought I heard, Greg, you asked about original methods, originalism, how that would work. So I thought I would give that a stab. So I guess the original methods, originalism, would look to the original interpretive rules. So the first question you would ask, I suppose, is would the framers' generation have looked to dictionaries in the defining terms? And I guess you could, I hadn't really thought of this before the second, but I guess you could ask that question about whether they looked to dictionaries for words that were 150 years old in their time, right? So, but putting aside that issue, presumably they didn't often look to dictionaries, and I guess the reason is they felt like they knew what the words meant. It was their language. So if you didn't have an actual explicit or followed interpretive rule, then you might actually, but of course, when interpreting things, they wanted to look to the meanings. And so we could, in trying to follow their interpretive rule of figuring out what the meanings are, look to dictionaries as an indirect way of getting at meanings, right? So it wouldn't actually be one of their interpretive rules, but it would be our attempt to follow their interpretive rule. That, I think, would all be okay unless they had a rule that said, don't look at dictionaries. In which case, that'd be more difficult, although it still would be more complicated. You can actually run this same analysis through the kind of legislative history, legislative debates issue, right? So the first question is, you look to, did they have an interpretive rule to look at legislative history and debates? And I think probably the answer was no, that there really wasn't any. So they don't have that. You might then think, okay, well, we can look at the legislative history and the legislative debates to find meanings of words, sort of an indirect way of using the legislative history and debates as evidence of words. It might be different if you were looking to intent. And again, that would be okay unless, of course, they had a rule. And some people actually say they had this rule. Don't look at legislative history or debates, in which case things would get more complicated and you have to figure out what that rule meant. Don't look at it for meaning as opposed to don't look at it for intent. Anyway, so that's how I think the analysis would work. One other small little point, maybe you said this. I think the reason why people look at Noah Webster from 1828, it's the first American dictionary. So Johnson is, and the others are English dictionaries.
Randy Burnett.
Great. I have a criticism and then I have a comment. Some of my comment was anticipated by Greg's last remarks. The criticism is that I think there's a kind of a strange omission of the dictionaries that you decided to survey. Given Supreme Court practice, I should think that Webster's 1966 dictionary should have been included, since the decision in the Raich case turned on that use of that dictionary. So it's odd that, given Supreme Court practice, you wouldn't include that in your list of dictionaries. And on a more serious note, you might actually use this as a laugh line in your piece about the use of dictionaries. Can be every sort of a reductio ad absurdum of why is Webster's 66 dictionary being used there, and why is it kind of silly that it was, even though I'm somewhat grateful that it was, because it meant that they didn't overrule Lopez and Morrison because of this dictionary, so that was great. My comment was actually provoked by what Steve was talking about in terms of, it seems odd that we're looking at these dictionaries, and why are we doing that? And I think part of it is it's a defensive mechanism against tendency amongst progressives to take the language of the Constitution, try to operate within the language of the Constitution by stretching, bending, shaping the words in the Constitution. And so when you're trying to push back against that, you look at a dictionary as a kind of an objective. It's not just me saying it, but look, this is how the word used. And Krosky is the guy I had in mind. This is what you anticipate by raising Krosky. Before I did my Commerce Clause research, I read the whole Krosky thing, and believe me, you think Atlas Shrugged is long. This is a lot. So 3 volumes. There's a third one. And after I read that, I thought, well, gosh, I go out there. There's got to be this diversity of usage. There's got to be. It's just because look at this. And then you do the survey, the comprehensive survey of every use of the word, and not once does it get used the way Krosky says in this database. And you go look at another database. Never once does it get used of. And so, dictionary was a good start, but then, so that's part of it. It's defensive. As you say, it's odd, but it isn't odd if somebody's foisting upon you some meaning that you're going to have to push back on. And then I think it actually does serve this purpose that Greg mentioned, which is it's a checking thing. I mean, it's hard for people to replicate other people's research. So, I say I looked at every single usage, and I'm going to, and I think it's useful, by the way, to look at every single usage in whatever database you talk about, and then report on everything you found, including deviant usage and prevailing usage and things that come close to the line. I charge research assistants when I was researching the Philadelphia Gazette, the Pennsylvania Gazette, to look at every usage and identify to me, single out to me, anything that came even close to the line, because I want to be able to review that separately. And then I reported everything they reported to me as close to the line, and arguing why I didn't think it even came close. But they were charged with doing it. So I think if you do that, your readers can trust your reporting better. But still, it's hard to trust other people's reporting. And the nice thing about dictionaries is that you didn't make it up, and as long as you report all the dictionaries. So anyway, that's I think a function of why dictionaries are useful.
I had a couple thoughts. One was the first few times I tried to look up something in Noah Webster's dictionary from the Constitution, all he did was point me back to the Constitution. So, in his definitions is, well, the Constitution uses this term, so all you find out is if you even find out that, is what Noah Webster thought in 1828 about the Constitution. So I don't know how much you've noticed that. The second thought, if you look, I know this term gets used in like biblical lexicons and stuff. They talk about semantic domains. And the whole point is not that you're trying to find a context-free definition, but this is the range of different meanings, and you have to figure out which one it is based on the context. So it's sort of in response to Marty's point.
One last thing that I forgot to mention in response to Larry's point, and that is that when dictionary definitions substitute and why that can be harmful. Marshall's substitution of intercourse for commerce is a good example of that. And after that, all people talk about is this intercourse or not? And then you have Balkan substituting interaction for intercourse, and we're off to the races. Even though the original meaning of intercourse, the first definition of intercourse is commerce, and intercourse is actually the transmitting of something from one place to another, which is very commerce-like. So, but that's not how it's used. So when you place one with the other, now you're in another realm. So I agree with you about that.
Could be a special case on the desire to make, risque references or something.
You were the third, yes. So all very, very helpful comments, Mike. I'm going to have to study this original interpretation. And you threw out a whole bunch of things there. And did they look at 150-year-old dictionaries? I guess if they looked at the current dictionaries, I think there are some citations, early citations of Johnson's dictionary by the Supreme Court. So maybe that's, we can continue to look at that. I'll have to study that. Yeah, Randy, I like your idea that this is a defense against stretching the boundary, stretching and bending words, then as a sort of defense mechanism. One thing that I find really interesting, though, is just how much ridicule citations of dictionaries is subjected to. It's from the stretchers, yeah, but in a typical law school, this is not a typical collection of law professors, but in a typical group, if you said at a typical faculty meeting that, I think Justice Scalia was right. Among other things, he said in a dictionary. That would be laughed out of court or out of the faculty meeting or whatever. It is interesting that they were like that. I'll have to look at, I'm trying to write a paragraph or two about each of the dictionaries. And I think that specific point that you have, that Webster cites the Constitution, renders it less persuasive about what the Constitution means. I think that it's self-referential. That's also a problem in legal dictionaries. A lot of legal dictionaries cite other cases, and the cases cite other sources, and you never really get to the bottom of everything. It's all just floating around there.
Okay, and then we have Gerard, John McGinnis, Bob Bennett.
Right. Well, I think most of my question has been taken up by the last set of comments. I mean, my only added thought or comment is just that it would seem that Chief Justice Marshall in McCulloch, as you point out, and then in Gibbons, as Randy just pointed out, is the kind of the leading stretcher or person who doesn't want to use dictionaries and wants to define terms himself. So I guess the question is, to what extent does that call into question the use of dictionaries more generally, if these sort of canonical opinions don't do that? But the rest has already been sort of asked and answered.
John McGinnis.
It's a very interesting paper, Greg. I think there would be very useful to have a whole section on the weight and interrelations of dictionaries. I don't know about how dictionaries were written, but I suspect that sometime one compiler looked at another dictionary. And if that's the case, if we want to, and as I think you suggest, and as Larry Solon suggests, we want to triangulate, well, that changes the weight of our triangulation. Just by looking at a variety of newspaper copies that say the same thing, we have less weight than if they're actually independent sources. And so I think this will be much helped by showing the interrelations of the dictionaries at the time. Similarly, I think it'd be, you say Johnson's dictionary is the most cited. It'd be interesting to see how the others are cited. It might also be interesting to see in what context they're cited. If some of the dictionaries are cited in more formal context, you might think that they are going to have more weight in that area. In other words, it's not just a number of citations, but it's the context of the citation. And one way you may measure that is you look at where the dictionaries are cited, how often and in what context they're cited, to understand the whole contextual weight. I know that sounds sort of complicated, but I think one could at least begin doing that. I think we'd have then a better sense of how to triangulate, because I do think that is a matter of giving these various dictionaries weight.
Bob Ben.
I was wondering whether it might not be important to treat the use of dictionaries by scholars differently from the use of dictionaries by judges. Because it seems to me you might think about the costs and benefits differently in the two contexts. There are lots of helpful things that can be gotten from dictionaries. We've talked about those. There are also lots of possibilities of being misled. We've talked about those. Almost everybody here who's addressed it has suggested that you shouldn't rely solely on dictionaries, even when they can be helpful, but look more broadly at the various usages that were around at the time to verify or modify your take on dictionaries. And that seems absolutely right to me. But even for scholars, there's a temptation, going to be a temptation, to rely on the dictionary because it's easier. Even with John's big data, the dictionary is going to be easier. And once you transpose it to the courts, easier is much more attractive. It's not just courts. I teach contracts. I have a question of contracts. I look up Farnsworth. I'm very unlikely to go beyond that to read the 7 cases that he may cite in a footnote. Sometimes I may, but usually I won't. Usually a court won't go beyond the dictionary, and that's perhaps a big enough danger given the downsides of using dictionaries. Maybe you might want to reach a conclusion that courts should avoid them altogether.
George, make a really good point about Chief Justice Marshall, and in fact, I felt a little silly in citing the example of necessary and proper, where I point out that, well, maybe Samuel Johnson's dictionary is defective because it doesn't have the definition of necessary, or incomplete because it doesn't have the definition of necessary that Marshall thinks is in the Constitution. It could also be the opposite, which is that Marshall is not quite right on that. John, I do want to say a few more things in that I haven't finished the last supplement, the appendix about the dictionaries. Johnson's dictionary is one of the best dictionaries because he started over from scratch. There had been many dictionaries beforehand, and I'm certain he consulted them because he put in about, I think it was something like 40,000 definitions all by himself. But what he did is he found famous speakers who had used these words, and he listed them next to the dictionary definitions. Other dictionaries like Sheridan's was derivative of Johnson's. Sheridan wanted to add pronunciation and other aspects, and so other things like that, although he did add some additional words. I think knowing the history of these dictionaries would be very helpful. I am worried that this is way beyond my ability to try to figure out which dictionaries are in which best used in which context. I also think that at a certain point, we might be trying to add too much precision to a tool that can't be sharpened so finely. I mean, we're trying to make a spade exactly symmetrical or something when in the end it's kind of just a spade. So if I could find clear examples, like, when you're talking about judges, you should always, or Article 3 questions, it always should be Johnson, but Article 1 questions always should be Sheridan. If you could find that, I think that would be very helpful. As you yourself suggested, it sounds pretty difficult. Yeah, I think the difference between judges and scholars, it may be great, it may not be great. I think that it may be worthwhile for people to know what the original meaning of the Constitution is, regardless of whether you think judges should have to follow the original meaning of the Constitution, just as a historical matter. And I kind of reject the idea that you can never know anything about history. And so often in the past when I've presented my other guides, someone always says, yeah, but, how are we ever going to figure out the original meaning of the Constitution? And it's usually we don't want to follow the original meaning of the Constitution, as opposed to there's no way to figure out what the document meant, because there's whole departments of history, and there's lots of history books. I don't really think that there's that much difference. I do think that's a separate question from whether judges should follow them. I think it's too big a question to take on whether judges should avoid dictionaries altogether. I also don't think that it makes sense to say you should exclude an entire source. Why wouldn't you want to know what the dictionary said, even if you're not going to follow it necessarily? I think you're right that easier is more attractive, and that's why I think judges they don't all do what Randy did in his article. Maybe they should do that, or have an amicus brief do that on a really big case, but it's unrealistic to think it's going to happen very often.
Okay, Larry Solom, Michael Connell, and I think David Owen. Okay.
So this is not a comment about the paper, it's just a comment about life, where originalist scholarship, or comment about life, where originalist scholarship might go. So I think that it's absolutely right that the reason we use dictionaries frequently is that it's cheap in terms of hours of research, right? Whereas even given the accessibility of computerized databases, it takes time to process through large quantities of usage and identify the pattern. So I think that's why judges and law clerks are especially likely to rely on dictionaries, because they're doing their work in a time-constrained way, right? You're not going to take one of your 4 law clerks and say, spend a year, right, doing a comprehensive evaluation of, all of the relevant usages in the available databases and the available corpuses of usages. So, but we could do that, right? And it seems to me that there'd be a lot of use to sort of a version of originalist scholarship that was interested in supplementing the available sources, right? And you could imagine this going in various ways. It might be that there's a law review article, or it might be that there's a project similar to the Founders Constitution, right, that just identifies large numbers of usages and makes the information available in a form that's usable by judges. So, Greg, just to tie this into your, I know this isn't a question for you, but just to tie it into your project, so your project is to take the existing sources and sort of you identify a source and then you provide a really handy guide to how to use that source in an intelligent way. But originalists, I think, ought to be asking the question, sort of, are there new sources that need to be created? Right? And I think there probably are. And I think the big data point, right, suggests that there are some efficient ways of creating things that would be very useful to judges and lawyers that don't exist yet. And that might be a worthwhile enterprise for originalist scholars.
Just a quick comment inspired by Mike Rappaport's musings about original methods and the use of dictionaries, just that there is one striking almost use of a dictionary, which is when the term ex post facto law comes up. And it's interesting because the next day Dickinson comes back, this is in Madison's notes, Dickinson comes back and says he looked it up in Blackstone, and the term just applies to criminal laws, and and as a result of that, they add the contracts clause, which tells us, a couple of things. One is that there are at least some terms in the Constitution that are legal meaning and not probably colloquial public meaning. And secondly, they did believe in definitions and thought that and applied them and worked from them. So anyway, just an episode.
Just a quick comment about Noah Webster's. Well, this might apply to any of the dictionary writers, but oftentimes people who write dictionaries might be doing something aspirational. They're trying to create some sort of linguistic harmony. In Noah Webster's case, that was part of his idea. It wasn't necessarily to, well, I don't know, but I know that he was very much a nationalist and interested in creating a national language. So he may not be simply reflecting statistical frequency of use, but trying to create synthesis of use. And in his case also, he was a strong, and this cuts both ways in terms of his youth, he was a strong proponent of the Constitution and participated in the ratification debates in New York.
Well, all very useful points, Larry. I think you're right. It's a big project just to figure out, to give people guidance on existing sources, but big data is a new source, and it's useful. And I think there may be other useful sources, too. I like the ex post facto clause. That's a good original methods point of data. And yes, it's very much true. It wasn't just Webster. All the dictionary authors they all created prescriptive dictionaries at that time, trying to tell you the right way to use words as opposed to just this is how words are being used. And in fact, I think it was Webster's 66 dictionary where they first came out and said, oh, we're not taking any position on what's right or wrong. We're just going to tell you how the words are used. And so there is this distinction. I don't know how much that differs because I think that Gouverneur Morris and everyone was using the words, the way they ought to have been used. I mean, he was a fancy stylist. There was no slang or unusual words. But I think you're right that you have to be very careful. If you're looking at a prescriptive dictionary and thinking it's a descriptive dictionary, that could be a source of error. Thank you very, very much for these comments. I really appreciate them. I'm going to work on this.